Peace and Black Power, family. This is your brother Shakim Amenhotep Akhet. Right, Black Action once again. Earlier today, one of the Caananland Moors from RV Bay Productions put out some false propaganda about the issue I was speaking on, dealing with bloodshed versus paperwork, and why bloodshed historically has been the only thing that has allowed a nation to be able to rule with sovereignty and to govern itself as an independent state and establish their own nationality. Now, what I'm gonna do is point out some bullshit in RV Bay Productions, and I'm gonna show you why these individuals prey on people who don't have a thorough understanding of law in totality. They don't understand how the court system works that they're in, and they don't understand or have a thorough understanding of white supremacy. Now you can get down to terminology and, trying to use wordplay and be vague and ambiguous and go on and on and on with these devils, but I'm gonna show these niggas how white supremacy actually works, and how if you don't understand white supremacy, then looking at all of this shit right here, it looks good, but you don't see how those major factors come into play. Now, one thing that you will always see is brothers making arguments in favor of what they say, but you'll never see them actually put up what happens to brothers when they go in the courtroom. And one thing about law is that on a magistrate level, you might not have opinions recorded. You don't have them published. But at the district level and at the Supreme Court level, you will see opinions being published, and you will see the layouts of the cases, and you will begin to see how judges actually interpreted the law. And you would have to be foolish to think that none of these brothers ever went into a district court or above and actually had these arguments put forth in front of a court and see how the cases will rule. So what I'm gonna do is show you how cases that the arguments that they put forth in front of these judges have come back shot down, null and void, moot, frivolous, and all the other words that these judges use whenever they render their decision. Now, one thing that I'm gonna ask before I start, for any more, show me where at a district level or a Supreme Court level or an appellate level, show me a case where a Moor has won. Don't come to me about some magistrate court where you walked in, abracadabra, bedazzled a judge and a jury and a lawyer and walked out of there. You can't show me on an appellate level or a district level where these people have won. Now, when a lawyer puts forth a case, the adept lawyer, what they do is they look at cases in other districts that have been ruled on in favor. And what they do is they use a set of cases that backed up their claim to actually go and show and prove in front of this judge or this administrator. They go and show how other courts or jurisdictions have ruled in favor of people who had like cases, and they use that argument and they use that as a foundation for what they're trying to do now. Remember, law is a practice and law deals with interpretation. That's why it changes so frequently. Now, a brother told me a long time ago when I walked into the law library when I was in prison, he said, youngster, where a lot of brothers mess up at is when they study, they only look at arguments that were used for them to win. They only look at situations where they think they can win. He said, but if you want to be successful in learning the law, when you put together an argument, you need to understand and see where you've lost so that you can kind of restructure and tailor your argument a little better, because you see where somebody went down that same path and they lost. Now, what the Moors do when they go into court they do is they run their mouth, use wordplay, and they lose. They don't really give you anything of substance. They quote old law from 1940, 1930. They don't show you anything up to date from 2008, 9, 10, 11, 12. What they won, they just go back and reiterate the same arguments over and over again that have already been educated or ruled upon. Now, let's go to this fraud-ass R.V. Bay publications. Now I'm going to beat this shit up real quick. So this is what he says. There are 3 things placed before the court as a matter of protocol prior to education. The first thing he says is status. Now, I agree about a person's status. I agree with a lot of the things that actually are espoused concerning nationality. I understand that. I understand that. Because I know when a people come together and have an identity, that's powerful. But where we disagree at is, I say that when the European comes in and says, we don't respect what you're doing, the next step is you have to go to war if you want an independent state and you're fighting for freedom. So if you really want to go further and take it to where you are an established state of a nation that has a nationality, you have to go to war. So he says the first thing is status. Your social standing in the community. Are you flesh and blood, a natural person, a corporate person, an artificial construct? Jurisdiction. Where are you? Is it lawful courtroom or tribunal? Does it have personam jurisdiction, or basically jurisdiction over the person? Back to the status, which determines that. So he's saying that for a court to have jurisdiction over you, it all goes back to your status. Now, I'm going to show you where this argument has been used by Moors recently, going in the courtroom, and I'm going to show you what white supremacy has ruled. Let's dig into this shit, man. Now, Pope vs. Amen, 2013, decided on December the 23rd, 2013, criminal court, the city of New York, Queens County. Now, I'm going to show you cases where you can go back and read and find this stuff. I'm not just going to come up here making an argument. I'm going to show you where the arguments that they've used have been beat down by white supremacy. Now, in this case, the defendant has moved for dismissal of the accusatory instrument on the basis that this court lacks in personam jurisdiction over him, or saying that he's going to show the defendant has moved to dismiss the indictment because he's saying the court lacks jurisdiction over him. Now, it says, the people have not filed an affirmation of opposition for the reasons set below. The defendant's motion is denied. Now, remember what R.V. Bay just said, and I'm going to go back to it. He said that jurisdiction over the person is determined because of the status. Now, the defendant claims that he is a member of Moorish American nation, and as such, this court lacks jurisdiction over him. This challenge by self-identified members of the Moorish American nation have previously been raised in both state and federal courts and is consistently rejected. Now, it even goes to cite cases where they've been rejected. I'm going to pull something up for you, and you can pull them up yourself. He has Caananland Bay versus the IRS. United States versus James. Now, it says that the court's authority to adjudicate the pending action is clearly set forth in the New York State Constitution. Now, it says that New York shall have jurisdiction over crimes and other violations of law, and it says, hence, in personam jurisdiction, or jurisdiction confers upon the defendant not by his status or non-status, but as a citizen of the United States, but by his presence within its borders. jurisdiction is based first and foremost by a person's status, but white supremacy shut that shit down just in 2013 in December. Not even 2 years ago. They shut that shit down, and they told you that jurisdiction doesn't confer upon the defendant by his status or non-status as a citizen, but by his presence within the borders of the territory that white supremacy is now ruling. And you gonna tell me some dumb shit on your website about jurisdiction is based on status? See, now you lying to the people, and when motherfuckers go out and research this dumb shit you done put up, that shit is smashed. It says the laws of the United States apply to all persons within its borders, regardless of the person's citizenship, nationality, or status as a stateless person. Therefore, this court has jurisdiction over the defendant and over the criminal offenses charged in the accusatory instrument, all of which the defendant is alleged to have committed in the county of Queens, according to the defendant's motion to dismiss for a lack of jurisdiction. It's denied. This opinion constitutes the decision and order of the court. Now, what I want you Moors to do, are you brothers who ride in RV Bay publications, go back and research and show me a case in a district court or a Supreme Court or any appellate court where they have actually won due to a lack of jurisdiction because of a person's status. Nigga, come show me. I'm showing you where white supremacy is telling you that what you saying right now is wrong and you lying to the people. The only way that you can come and establish your own state and govern yourself is through wars. The white man is showing you right now that he doesn't respect that shit you putting up. And because you are living in the state of the colonizer and he has jurisdiction over this land through war, now we are subjected to what's in his borders. It tells you right here. The court has jurisdiction over the defendant and over the criminal offenses charged. The laws of the United States apply to all persons within its borders, regardless of your citizenship, nationality, or status as a stateless person. But you still gonna turn around and publish some bullshit like this that states that jurisdiction over the person actually determines your because of your status. And what you fail to realize, right, is individuals who sit back and they question this shit, you don't have any sort of information to go by as a rebuttal to say what you have is correct. Now you can put forth an argument, that argument may be valid, but like I stated, it's the ruling forces of white supremacy who have the ability to interpret the law and render a judgment. Now, here's another case. Supreme Court of the state of New York, Bronx County, Williams Bay versus Webster Park Avenue Housing Development. Now, here comes another motherfucker who been reading up on RV Bay publications, and he goes into these courtrooms where these white supremacists run and trying to use the same thing. Now, I'm gonna show you again. Moorish American status. Here, Williams Bay. It says, the plaintiff inartfully asserts special status for himself in the caption as a Moorish American, but refers only briefly to Aboriginal and divine rights in his complaint while rejecting the Anglo law. They do this all the time. Plaintiff says he's a Moorish American national based upon, here's the title, here's the code, claiming citizenship under the United States Code. There it goes. Now, it says, plaintiff purports to limit his involvement here to a limited appearance, special appearance, or restricted appearance. The challenge to jurisdiction of American courts over members of the Moorish American nation has been tried in both federal and state courts, always to no avail. Here, they're saying always. They didn't say sometime. The courts have ruled that brothers have tried this in Now, one thing about an argument in court, if I'm a Moor, if I'm one of these brothers, Williams Bay, or any other Bay or L or whatever, that goes in the courtroom, if I got so many people telling me that they've won these cases, when I get in front of the court, why not use their case as an argument to show the people where other districts or other locales have ruled in our favor that they don't have jurisdiction over me because I am a Moorish American national? Brothers don't use that. When they go in the courtroom, they're not saying, oh, well, I have a case, such and such Bay or such and such L came in the 4th district and it was ruled that jurisdiction was lacking because he had special status and he was not subjected to the terms Negro, Black, Colored, or Ethiopian. They're not going to show you that. They're going to ramble on some shit that happened in a municipal court with some more misdemeanor traffic shit, and then they're gonna show themselves walking out laughing. But you don't never see a motherfucker walking out of laughing in no Supreme Court or no district court, federal or state. Because they lying to you, and niggas ain't doing the research. It says, under the facts of this case, the court finds the plaintiff's jurisdictional argument unpersuasive. While the court cannot say there are no circumstances under which Moorish American status cannot find recognition, plaintiff fails to make significant showing to categorize himself as a cognizable here, even where the court would treat the plaintiff as a member of such cognizable group. That status would confer no special benefits to the plaintiff under these facts. So what it's saying is that, yeah, there might be a situation to where we could recognize you as a Moorish American, but still, even if the court were to say that you were a Moorish American and recognize it, guess what? It says that status would confer no special benefits to the plaintiff under these facts. Here's the case right here. Supreme Court of the State of New York, Bronx County, Williams Bay versus Webster Park Avenue Housing Development, 2010. I'm not showing you no bullshit from 1940, 1860, 1844. This is the current state of white supremacy. That is why I'm telling you that the only way that we will begin to be able to defeat this beast right here through law is if we defeat them militarily and set up our own. And if we don't defeat them militarily, then we need to go to a place that welcomes us to where we can establish our own and build our own and grow agriculturally and grow economically and establish our own territorial boundaries to where we can protect it and where we can grow our own food and where we can establish our own culture and live peacefully amongst ourselves. If we can't do it somewhere else, if we try to do it here, it's only going to result in a war with bloodshed. Come on, man. And see, what happened is these dudes think they're playing with lightweights, and then they get up showing these little videos of they dunce cap swinging in a courtroom, but they ain't getting nowhere, bro. This is what you can go research. 2010, the other one, 2013. I ain't going back in the graveyard. I'm going through shit now. Where you can go pull up these cases. Here we go. Now, you got these niggas talking about the Treaty of Peace and Friendship between Morocco and the United States. Going back, citing this bullshit in the courtroom about some agreement between two slave masters in 1787. Go do the history of the relationship between the United States and Morocco. Now they say, oh, because we Moors and the peace of friendship has been established, then you don't have jurisdiction over me because I am not Negro, Black, Colored, or Ethiopian. I'm a Moor. See, they're going to take you to shit 1787. They're going to take you to shit 1840. They're going to take you to 1820. But keep in mind, these arguments have already been ruled upon like the... Okay. It says the challenge to jurisdiction of American courts over members of the Moorish American nation has been tried in both federal and state courts always. always to no avail. Not sometime, always. Here we go. Peace and friendship treaty. Let's see how this shit done got bust down. Y'all niggas playing games, man. Y'all fucking with the right one, man, because people like me, we gonna do our research and we know and understand what's right and exact, and we not just gonna take some bullshit RV publications put up and then run with it in no courtroom. See, dudes done did this before and done got their shit split. So I'm showing you what happens. Now, look at this shit here. All right, here we go. Another case decided in 2008. There goes the caption. If you wanna look it up, here it goes. District of Columbia, Court of Appeals, Eric and Pitt Bay. This can be found on caselawfindlaw.com. It says, we consider first and reject, we consider first and reject the appellant's claim that he is immune from prosecution in the Superior Court of the District of Columbia. The appellant argues that even though he is a United States citizen, having been born in Brooklyn, New York, as an associate member of the Council of the Nation of Moorish Americans, he should be accorded diplomatic immunity pursuant to federal law. Now, I'm gonna go down here to a point that stands out. It says, appellant also argues immunity from prosecution under the Moroccan-American Treaty of Peace and Friendship ratified by President Andrew Jackson on January 28, 1837. So now, remember what RV Bay Productions saying, hey, you could say the Treaty and Peace Friendship, 1787, that's going to help you in your case to establish the fact that this land does not have jurisdiction over you. Now let's see what white supremacy says. White supremacy says the Treaty of Peace and Friendship, U.S. Morocco, as the title indicates, the treaty is one of peace and friendship between the sovereign states of Morocco and the United States, and it provides that subjects or citizens of each country will be held safe by the other, as well as a protocol for any confrontations that may arise between the two countries while at sea during trade or battle. It does not, look, it does not contain any language suggesting that the United States or any state or territory therein does not have jurisdiction over a person violating the law within its jurisdiction. Therefore, this treaty has no bearing on this case. You want to see more? There you go. There's the link. caselawfindlaw.com/DC Court of Appeals /146-7287. So now what happens is you get these brothers and they start quoting all of these old treaties and they're quoting all these old laws and the Negro codes and all that, and then they're telling you, yeah, as long as you don't say you're Negro, black, colored, Ethiopian, all that, you can go ahead and say you're a Moorish national, you got your little card. Look, check this out. I'm gonna keep going. It says appellant has not produced any evidence demonstrating he is diplomatic, staff, or a member of a qualified mission. In fact, U.S. citizens may not normally be a part of a diplomatic mission of another country unless the United States specifically, expressly consents to such an agreement. It says the appellant has only an official identification card of the Nation of Moorish American Inc., which identifies him as the executive vice president. According to the appellant's testimony at trial, the TNOMA is an organization that was incorporated as a sovereign body politic in the District of Columbia in '95. Appellant, therefore, is not a diplomatic staff representative of a sovereign nation recognized by the United States Department, the United States State Department, whose diplomatic staff are accorded various degrees degrees of immunity from prosecution. Now, here it states in the law in white supremacy that if they don't recognize you, as the State Department does not recognize you as a sovereign nation, then there's no way that white supremacy is going to allow you to be immune from prosecution in the United States. Come on now. Read this stuff. But what happens is we keep going back and forth, back and forth, back and forth with RV Bay Productions. We're going back and forth with these dudes, man. Going back and forth. And it's BS, it's folly. Here you go. If you let them get passed on status, if you let them get passed on status. So what you gonna do about it if they do? Now let's talk revolution. Come on, RV Bay Publications. Come on, Caananland Moors. If you let them get passed. So look at these brothers who let them get passed. You can't do nothing about it neither. So now this sentence says, if you let them get passed, if they get passed, tell me, what are you gonna do? What are you gonna do about it? You don't have no military, you don't have no economy, you don't have no government, you ain't got no weapons. What are you gonna do about it if they get passed? It says if you let them get passed on status, and you let them pass on status and jurisdiction, then the court moves to adjudication, the determination of penalties, punishment, sentencing, including court fees and fines. When you are dealing with the courts, you must ask for their delegation of authority in written form to be placed on record and entered into the record as evidence, as proof of their authority. It is a tangible document and a veriment of jurisdiction, and if they do not produce it, they don't have it, and technically the matter is closed. Ask and you shall receive. Get the fuck out of here. As a matter of fact, that's some bullshit, because if you think about it, they have already ruled on paper that they have jurisdiction on anybody within the borders, regardless of their status. What are you gonna do about it, Moore? See, we gotta stop letting these ignorant motherfuckers right here, man, convince you that filing paperwork and screaming this, status that, actually works. So now, my question is this. I'm willing to give any more $1,000 who can produce a case in a district or appellate court. I want to see the opinion of the court. Show me where, not no old 1845, 1846, show me where in writing a judge or a circuit judge has actually ruled that the United States government doesn't have jurisdiction over someone who is not in the so-called status of Negro, black, colored, or Ethiopian, has granted them the right to actually be immune to prosecution for any violation of a code or a law or a statute that's been established by white supremacy here on this land. Show and prove that. Now I gotta bring the heat to you niggas, because I ain't letting you off. You wanna make a video on some bullshit about me? Show me. I'm pretty sure some more, how y'all scream, some more has won. But see, y'all only stay at the magistrate level because you know that magistrate courts don't actually publish their opinions. But see, brothers like me who study law, we know and understand that you ain't got nothing coming from no district court. You don't have nothing from the Court of Appeals. They already saying in their cases that you have never won. And I'm gonna leave you with this, family. Man, y'all don't follow up this bullshit. I agree with nationality. That's the way how we identify ourselves. I'm in total agreement with it. But what I'm saying is that when you have conflicting interests, when you have white supremacists over here stating, and I'm just using the word white supremacy because we could defeat the motherfuckers now, So it ain't like I'm just giving in and saying, oh Lord, but I'm saying the avenue, if you want to have a complete sovereign and independent state, you have to eventually turn to bloodshed. Remember when I was talking about declarations? A declaration does not automatically give you that right to do what you want to do. The United States declared war against Great Britain. They signed the document, but as soon as that document was signed and it was delivered to Great Britain, they put an all-out warfare, and George Washington began leading his army against Great Britain to establish sovereignty in a land that was occupied by the British slave masters. You have the same thing with Kenya. Remember, they also, the Mau Mau, the Kenyan Land and Freedom Army, they also had an oath or a declaration that they would live by so that they can establish who they were and take over the land. And once they established that oath, they subsequently had to go to war so that they can back up what they were saying. But you right here, you have declared your nationality and you have declared your status as being a free national sovereign, but you have not gone to war. And now the white supremacist is saying that we don't accept what you're saying. And then you have, if you let them get passed on status, then what? The court moves to education, determination of penalties, punishment, sentencing, including court fees and fines. That's why you're losing right now. This shit is all talk. But at the end of the day, when the European says, guess what? You on our colony, you on our land, you can tell them, oh, we had the land first, all that shit. You go in there, the judge look at you, yeah, you had the land first. Okay, that sounds good. You had all that, all right, guess what? Boom, case dismissed. Get up out of here, I'll go to jail. Peace and Black Power, Shakim Amenhotep Aket, South Carolina RBG, the African Geechee Gullah warrior has spoken. Revolution and bloodshed versus paperwork. Peace, family.